any country that is going to stifle free debate and free speech in an open market, that's a country that's afraid of its own people. It's afraid of its own citizens. And when you carry out crimes as they do, you probably should be afraid of your own people, because sooner or later, everything that's done in the shadows is revealed in the light.
Mr. Chairman, I'd like to turn to an issue. Last November, the SEC announced a massive increase in enforcement fines, $6.4 billion in 22, up from $3.8 billion in 21. And you have launched a regulatory crusade against the financial service industry through enforcement. You've told us that. We see this. Can you please tell me what the money from these enforcement actions, what you've done with it?
He has a poor track record on fasting. He was once accused of using vulgar language, but he said the accusation was bullshit. He loves the smell of gasoline and burning oil around his motorcycles and never stops drinking Coke Zero. He hasn't learned how to walk away from a fight. He's been to hell and back more than once, bringing a few public companies along for the ride. Other clergy scoff at him. The SEC and Big Pharma try to, quote, silence him for good. But their efforts haven't had the intended effect. That's Father Emmanuel.
Growing up in Tirana, where the call to a dawn echoed from the spiraling minarets, was a powerful experience for her. Albanians were forced to convert to Islam under Ottoman rule. In 1967, under the Marxist-Leninist regime, Albania became the world's first atheist state and destroyed churches to eradicate Christianity, in a land where St. Paul once preached the gospel. Her grandfather fought as a guerrilla fighter, and her father commanded a tank brigade. When communism collapsed, there was an insurrection against the state, leading to anarchy. Albanian women are known for their resilience. It is said they are born from the barrel of a gun. As a teenager, her father was flown out of the country without notice on a military helicopter to save his life. From then on, she started sleeping with an AK-47 next to her bed. That's Presbytera Theodora.
George Jarkesy, who ran 2 hedge funds that the SEC alleged were fraudulent, had a case brought against him before an administrative law judge by the agency. Federal agencies like the SEC rely on a network of nearly 2,000 administrative law judges who report to them as part of the executive branch rather than the judicial branch. Last Thursday's Supreme Court decision in SEC versus Jarkesy grants defendants accused of fraud by the SEC the right to a jury trial. The 6-3 decision, in which Chief Justice John Roberts wrote for the majority, assures protection under the 7th Amendment to the U.S. Constitution and rolls back what critics have described as unconstitutional powers seized by the SEC and other federal agencies as part of a growing administrative state. Is it relevant that the landmark ruling was an SEC case, and what are the implications to capital markets?
These courts, these private sort of administrative courts, are the cornerstone of the administrative state, which has grown uncontrollably and created a sort of parallel or shadow government. Some people call it the fourth branch of government. I don't really think that's a fully accurate characterization. I think the more accurate characterization is to call it really the deep state. And that's comprised not of political appointees through a democratic process, but it's high-powered attorneys and bureaucrats who remain regardless if it's a Democratic or Republican government. Although I will say the current SEC is very much so liberal and run by liberals and has been for a very long time. And you see very much so a political ideology. No surprise, of course, their headquarters are located in Washington, D.C., one of the most liberal states. I think it's something like 75% Democratic. The real problem with the administrative law judges, however, is, as Chief Justice Roberts points out in his ruling, and I think he mentions it 91 times, is not only the violation of the 7th Amendment, which is the right to a impartial judge and jury, as I say, an Article 3 federal judge, but it also cuts through, quite frankly, this 5th Amendment, which is often overlooked because the 5th Amendment typically applies to criminal allegations and the SEC deals with civil matters. But the fact is, wherever life, liberty, or property is at stake, there needs to be a right to due process. And so to suggest that these government bureaucrats who, the deck is so incredibly stacked against the the accused, because you have commissioners who are often deciding these cases after they've conferred with these hand-picked employees called administrative law judges. And they've very often had numerous ex parte meetings with the prosecutors, which again are their own internal employees. There's not only the appearance of adjudicative bias, but it's a reality. So it's no surprise, whereas this SEC has, according to one 2015 study, has a success rate of about 69% in federal court, their success rate before their own ALJs is 90%, so about a 30% improvement. So to go before an ALJ is an incredibly tactical decision for the SEC. And, we believe that capital markets in the West, we believe capital markets should be transparent. And yet the cornerstone of our entire system of democracy, which rests on a fair and sound and uncorrupt judicial system, has allowed this sort of foundation of an administrative state where everything is being sort of done out of sight, behind closed doors, in the shadows, and then these allegations are being made. And it's no surprise, of course, that so many of the accused choose to settle with the SEC because they understand going into it, not entirely unlike the DOJ, that their chances of success before the SEC's own hand-picked employees is virtually nothing. And those prosecutors are held only to the most featherweight standard of evidence. So the evidentiary standard is based on a preponderance of evidence, which is so incredibly lightweight. And so the rules of evidence, which apply normally in a federal courtroom, do not apply in these ALJs. So the fact that this was finally overturned, and it didn't get as much attention as I feel as it should have, because later on there would be these other subsequent cases which would come out, which would get a little bit more mainstream media attention. But the Jarkesy case cannot be overlooked. It's incredibly important for finally putting an end to the madness of these kangaroo courts that keeps this insular and sort of incestuous cabal almost of lawyers who are running sort of the show behind closed doors. They have the power, and those on Wall Street know this, right? Like, if you fall in their crosshairs, good luck getting out of that. The truth stops mattering because they're going to get what they want. They're going to get the outcome they want because there's no real due process. And there certainly isn't an Article III judge, and there's no jury of your peers. You'll be deprived of your due process rights. You'll be deprived of your constitutional rights in the Fifth and Seventh Amendment. And frankly, the SEC will take it even further, which we can talk about later. But there's absolutely no way that if you're caught in their crosshairs, you're going to walk away unscathed. And that should be very, very concerning to everyone, because we're dealing with an agency and a regulator that should be more concerned with transparency than any other. Because financial markets, to operate functionally and to operate ethically and without corruption, require absolute transparency. And yet you have the supposed cop on the beat being the least transparent of them all.
The day after Jarkesy was decided, while the national media focused on President Joe Biden's debate performance with former President Donald Trump, the U.S. Supreme Court ruled in Loper Bright v. Raimondo, which will likely have an even more significant impact on federal public policy. The decision rescinded the long-standing Chevron Deference judicial doctrine. Critics have pointed out that Chevron enabled regulatory agencies like the SEC to greatly expand their authority through rulemaking, which shaped the contours and definition of laws with minimal judicial review. This ruling makes it even more difficult for aggressive regulators, including the SEC, to continue expanding the scope of their authority as they have been doing for decades. What does it mean for court challenges to existing rules and regulations, and what are the broader implications? Why is the Supreme Court decision so important?
This ruling is especially important for the SEC amongst federal regulators because the SEC holds the keys to Wall Street. I could understand where we could say that, okay, offloading some of this responsibility for the interpretation of ambiguity in laws that Congress enacts might fall to experts if it was the EPA or something like that, or the National Fisheries. But the reality is that judges, the Article III judges, really need to be the interpreter of these laws, and they really shouldn't be ambiguous to begin with. And what rulemaking has become, rulemaking is really just a euphemism for making their own laws. And when bureaucrats and lawyers get to make up their own laws that are self-serving, particularly where there's money involved, it's been said, obviously, that the love of money is the root of all kinds of evil. So think about the SEC. I mean, that's where the money's at. It's not in the EPA. It's not in the other federal regulatory agencies. And what's happened, essentially, is you have a regulator that's supposed to be the cop for Wall Street has really become completely a captured agency. It's corrupt. It's a cabal of lawyers. And what they've done is they've done something really that no other regulatory agency has done. They haven't only managed to evaluate the Fifth and Seventh Amendments, which other regulators have been able to do that as well because of this policy, which has enabled the growth, the extraordinary growth of the administrative state. But really what the SEC has done is they've managed to do something even more incredible. They violated the First Amendment. And it's interesting that amongst all federal regulatory agencies, are the only one who consistently insists, for example, on gag orders and their settlements. And a huge number of their cases are resolved through settlements. I believe it's somewhere north of 90%, for example. Now, why would you want a gag order? Why would the commission want a gag order, right? The commission oversees what? Wall Street. They want transparency. We want openness. We want debate. We want disclosure, right? And we talk about corporate disclosures and SEC filings. And yet the SEC themselves, who are first running these kangaroo courts, like we talked about in Jarkesy, is now insisting that the people that they sue agree to gag orders. Well, I would say that there's a crime and then there's silence. And you can't overlook the reality of that. Why would you want a gag order? That's La Cosa Nostra stuff. Well, what I've seen in the SEC, and this is the really remarkable part of it, is in its ideological aims and its political goals, which is really what it's become. It's become the regulator of the executive branch under liberal Democrats that enacts not only the silencing of its opponents for political ends, but has achieved this by piecing together two different statutes. So they were able to take 10B, which is an anti-fraud statute enacted by Congress, and they were able to cobble that together with another statute, 17A. Now, 10B deals with fraudulent acts, fraudulent or deceptive acts. Actually, the word fraud isn't even used in the statute. It's deceptive or manipulative acts. 17A deals with the making of misstatements or the omission of facts that would make a statement misleading in order to obtain money or other property. When the SEC cobbled these things together, and they did it very, very hastily, getting comments from only one commissioner, they created 10b-5, a so-called rule, which actually functions more like a law. And what 10b-5 does essentially is that it enables and empowers the SEC to be the most incredible regulator of speech. I mean, they have really become the ministry of truth in that agency and in that regulatory body. And they can control what companies and individuals say and don't say to such an extraordinary degree that it's as if the First Amendment doesn't even apply at all. So what happens? You say on the one hand, well, rulemaking is good because it empowers regulatory enforcement action. That sounds really good on the surface, and I would agree with it if that's what actually happens in practice. But like so many other things in politics, you actually have to look at it and is the inverse. What it really does, rulemaking, is it gives the power to this regulatory body, which is now controlling speech, which is therefore controlling transparency in markets. Because what? Not only can people not say what they really want to say, they can't criticize, right? Because 10b-5 becomes the statute that controls speech. It criminalizes speech, essentially. And with this cudgel hanging over people's heads, everyone on Wall Street can't speak, even the whistleblowers. So you have people who cannot speak out. And then you have the would-be recipients of that information that, frankly, their First Amendment rights are also being violated because they have a right, a constitutional right, to hear opposing views. So once the SEC seizes this power through rulemaking, through the creation of 10b-5, and the only comment they got from the one sole commissioner who commented on before it was approved was, we're in the business of preventing fraud, something to that effect. Not exactly a constitutional scholar, you could say. So the SEC, this group now, who we assume is good, they're these guys who are supposed to be looking out for fraud, run probably the biggest regulatory revolving door in the history of the United States, with lawyers going from the commission to private practice to private law firms, which are very large and very powerful. And who are they going to be representing when they leave the commission after they've built their resumes on taxpayer dollars? You know who they're going to be working for? They're going to be working for the very same companies they were supposed to be regulating. So tell me this, do you really think that they would go after those companies when they're making, say, $250,000 a year, when they're going to leave the commission and go to work for some white shoe law firm on Madison Avenue making 10 times that? Of course they're not. So it is foolish to think that the SEC, with the power to silence speech, with the power to silence anyone, and it's so incredibly vague, 10b-5, right? It's a misstatement, or it could be an omission of a fact. It could maybe make it misleading. The SEC has actually argued in cases that a true statement is somehow misleading once they take, say, a fragment of a sentence, cherry pick it out of context, twist it and turn it and confuse it, and then allege that somehow it was misleading, and use that to silence the critics, and use that to silence critics of publicly traded companies. And that's why Wall Street has become an infestation of fraud. And frankly, the SEC is as well. It's probably by far the most corrupt, criminally corrupt and captured regulator in this country. And it's run by these narcissists who are completely ancestrally arrogant. A culture, a toxic culture run by angry anti-Christian feminists, hyper-feminists, man-hating misandrists, forming laws to silence dissent, who are driven by this sort of anti-patriarchal, anti-Christian culture, which is also fueled by greed. And if you saw the corruption, if you saw the actual connections between those people going in and out of the SEC and the jobs and the position they would hold later on, you would have probably the finest and greatest definition of deep state, administrative state you'll ever find. Yes, I'm sure you can find corruption in other government agencies, but you'll never find it on the level that you'll find in the SEC. So thank God that this was overturned, and so boldly overturned. It's a mythology that was created in the 1980s that this responsibility of judges to have sound discernment and judgment, interpreting the laws, these important laws, could be offloaded to people who have so many misaligned incentives. And you say, well, maybe they can't do ALJs anymore, maybe they can't do these kangaroo courts with the administrative law judges inside their own commission. But you know what? It doesn't really matter if they go to a federal court because they're willing to lie. They're willing to do anything to win. They're willing to withhold evidence. They're willing to withhold exculpatory evidence. They're willing to completely mislead and do anything to win their cases. Because if they don't win, as in the case with this Supreme Court ruling, it becomes increasingly evidence, frankly, the racket that they're running. So there's criminals on Wall Street, but the real criminals actually are their defense attorneys who are all trained in the commission. And that's why we have the Madoffs and the Enrons of the world. You ever wonder why those guys get along with their fraud for so long? Even though all the warning signs are there, the red flags are there, the purported investigations are there, because nobody really wants that fraud stopped. Do you think mortgage-backed security fraud? I mean, look who went to jail. Almost nobody went to jail. You know who went to jail? Realtors went to jail. Plumbers who bought a house, 2-car garages went to jail. Look at the guys. Look at the architects of the synthetic residential mortgage-backed securities. You ever wonder why nobody went to jail? That's not a coincidence. Occasionally, there's a sacrificial lamb Madoff at the end of his life. He was a sacrificial lamb. Martin Shkreli, sacrificial lamb. Nobody important, no systemic player ever really goes to jail because the people protecting and defending those companies, they're pals with the commissioners. They're pals with the insiders at the commission and the entire apparatus, which is completely corrupt. And it was this administrative state empowered by this incredibly bad doctrine, the Chevron Deference doctrine, which should never have existed, which gave rise to this sprawling administration. There should really be a study, if there isn't one on audio, what the actual economic cost is to the U.S. taxpayer, because these fools, they burn through millions, and I mean millions of taxpayer dollars to carry out their crimes, which they do most of the time in the shadows. And I'll tell you that, any country that is going to stifle free debate and free speech in an open market, that's a country that's afraid of its own people. It's afraid of its own citizens. And when you carry out crimes as they do, you probably should be afraid of your own people, because sooner or later, everything that's done in the shadows is revealed in the light.